All right, Friday morning, 8:17 a.m., one sentence on page 36 of a 54-page federal court order just became the line nobody inside the Justice Department wanted the public to read. Not the emergency deadline, not the disqualification language, not even the final warning buried near the end of the order. One sentence, 32 words, written after months of reviewing financial records, internal case logs, conflict disclosures, and warnings that moved through the system while the cases themselves were already shifting direction. And what that sentence says is not procedural. It is not technical. It is not something that can be brushed aside as another legal disagreement between lawyers. It says the strategic direction of 24 federal cases was materially influenced by financial considerations that worked against the government's own litigation position. Think about that carefully. 24 active federal cases, 21 months of decisions, nearly $390 million in litigation value. Pharmaceutical pricing, infrastructure fraud, environmental enforcement, civil rights, and a long list of other matters that were supposed to be handled in the name of the public interest. But according to the court's documented findings, those cases were moving inside a financial environment that repeatedly pushed strategy in the wrong direction. Discovery narrowed, witnesses removed, settlement authority reduced, expert testimony abandoned, internal objections ignored, and behind it all, a pattern of transfers appearing close enough to key decisions that the judge could no longer treat the sequence as coincidence. So tonight, we are going inside page 36, line by line, because this story does not move on headlines. It moves through court records. Subscribe now and stay with us, because the next filing could change everything. Page 36 did not appear out of thin air. That is the first thing we have to understand before anyone tries to reduce this order to politics, procedure, or another courtroom fight between lawyers. A federal judge does not write a sentence like that because something felt unusual. He does not put that kind of language into a permanent court record because one document looked suspicious or one timeline raised an eyebrow. He writes it after the record leaves him no clean way around it. For more than 180 days, the court reviewed financial records, internal case logs, conflict disclosure forms, private communications, and case management entries that stretched across 21 months. Not one case, not one decision, not one isolated mistake buried inside a chaotic federal docket. 24 active federal cases, nearly $390 million in litigation value, and a pattern that kept appearing no matter which file the court opened next. That is why the words on page 36 matter. The order did not say the cases were slightly affected. It did not say the decisions were possibly connected. It used a phrase with weight, materially influenced. In federal litigation, that word matters. Material influence means the pressure was not cosmetic. It means the influence was strong enough to shape direction, strong enough to change what was pursued, what was abandoned, what was narrowed, what was settled, and what the government left sitting outside the courtroom door. Then comes the second phrase, and this is where the finding turns from serious to explosive. Adverse to the government's litigation position. Not neutral, not debatable, not merely inconvenient. Adverse. The court was saying that financial considerations were not just floating somewhere in the background. They were pushing the strategic direction of federal cases in a way that worked against the very side these prosecutors were supposed to represent. And then comes the word that makes page 36 impossible to forget. Throughout. Not once, not twice, not in a handful of bad judgment calls that can be blamed on workload, confusion, or ordinary litigation pressure. Throughout the documented period, across 21 months, across 24 active cases, across a record that the judge had been building brick by brick before he ever reached that sentence. That is what makes this finding so difficult to dismiss, because page 36 is not the beginning of the story. It is the point where the judge finally says what the first 35 pages had already been proving. The financial relationships came first. The transfer pattern came next. The incomplete disclosures followed. The unanswered warnings stacked up behind them. And by the time the court reached page 36, the question was no longer whether something had gone wrong. The question was how long the system had known. Now here is where the order becomes more dangerous for everyone trying to dismiss it, because page 36 was not an accusation standing alone. It was the result of a structure, a foundation, a 6-month evidentiary construction project built one document at a time, one transfer at a time, one unexplained litigation decision at a time. The judge did not begin with the conclusion, he began with the money. Pages before the finding, the court laid out the financial relationships that senior members of the litigation team had with a connected network of private firms. Not past relationships that ended years earlier, not vague professional associations that could be explained away at a cocktail reception, ongoing financial interests, consulting streams, deferred compensation, revenue-sharing arrangements. And in at least 4 documented instances, relationships that disclosure forms described as limited, inactive, or fully resolved, while internal communications suggested those relationships were still alive. That matters, because conflict disclosure forms are not decorative paperwork. They are supposed to tell the court whether the lawyers standing in front of it are carrying obligations the public cannot see. And according to the order, those forms did not tell the whole story. Then the judge moved to the transfer pattern. 26 transfers, 21 months, approximately $5.3 million moving through the connected firm network. And the timing is what turns this from suspicious to alarming. Again and again, within 96 hours of those transfers, a strategic decision appeared inside an active federal case. Discovery was narrowed, a motion was withdrawn, settlement authority was lowered, expert testimony was abandoned, a witness list changed, a theory of liability was softened, and each time the direction moved the same way, away from the strongest position the government had previously taken. That is not how coincidence usually behaves. 1 coincidence can happen, 2 can be debated, 3 can be buried inside a complicated docket, but when the same pattern repeats across 24 federal cases, across pharmaceutical pricing, infrastructure fraud, environmental enforcement, civil rights, and financial misconduct, the court stops looking at fragments and starts looking at architecture. And the architecture was not subtle. 9 disclosure forms left out financial relationship details that later communications showed were known at the time. 4 internal case logs were edited within hours of disputed decisions. 7 senior review memos were marked strategy update without identifying the actual case-based reason. And in one 11-day period alone, the order tracked $740,000 in transfers, followed by 6 separate litigation shifts across 5 active matters. That is why this finding landed with the force it did. The judge was not asking the public to trust a theory. He was pointing to a record of money moving, a record of disclosures failing, a record of case strategy changing, a record of warnings rising, and a record of silence from the people who were supposed to stop it before it reached the courtroom. So stay with this channel and subscribe, because in the next chapter, we are going inside the 3 cases where this pattern stopped being abstract and became impossible to ignore. Now, let's move from the architecture to the cases themselves, because this is where the finding stops being abstract. The first case was the pharmaceutical pricing antitrust matter. On paper, it was one of the strongest enforcement actions in the group. Years of pricing data, internal communications, expert analysis, a damages model that placed potential exposure near $128 million. Then, over a 7-month stretch, the government's position began to shrink. 5 separate strategic decisions changed the shape of that case. A discovery request was narrowed, removing entire categories of pricing records from reach. A motion to compel internal methodology files was withdrawn after months of preparation. A damages expert was cut from the witness structure. A mediation framework previously rejected by career attorneys was suddenly accepted. And then the damages theory itself was adjusted downward by nearly 38%. Each move pointed in the same direction: less pressure, less evidence, less risk for the defendants. And according to the order, none of those decisions came with a documented case development strong enough to explain the shift. Then came the infrastructure contractor fraud prosecution. This was not a small matter buried in a quiet docket. The case involved federal contracts, public money, layered billing structures, and dozens of individual defendants. Before the disputed decisions began, the government's internal settlement authority reportedly sat at $112 million. After one transfer sequence, that authority was revised downward by $47 million. That was only the beginning. 17 individual defendants were effectively moved out of the primary liability theory. 2 forensic accounting experts were removed from the witness list. A 6-month delay was granted over internal objection. A venue transfer request that had already been opposed was suddenly treated as acceptable. But the most damaging part was not the strategy change, it was the reaction from inside the case. Career prosecutors filed 4 written objections. 4 times, the attorneys actually working the evidence warned that the new direction did not match the record and did not serve the prosecution's best interest. 4 objections, no meaningful response documented. Then came the environmental enforcement action, and this one is the cleanest illustration of what the judge appeared to be looking at. A key witness had cooperated for nearly 30 months. The documents were authenticated. The testimony had been prepared. The witness was central to proving the government's timeline. Then, within days of a $214,000 transfer, that witness disappeared from the list. The career environmental attorneys were not briefed beforehand. They did not approve it. They discovered the removal through a case management entry. The reason listed was only 2 words: strategic reassessment. No meeting memo, no evidentiary problem, no witness credibility note, no explanation from senior leadership. Just 2 words in a database, a missing witness, and a transfer close enough to make the court stop treating the pattern as noise. 3 cases, 3 different subject areas, 3 different litigation teams. But the same shape appeared each time. Money moved, strategy shifted, the government weakened. The record went silent where explanation should have been. Now this is the part of the record that changes the entire meaning of page 36. Because the question is not only whether money moved, whether strategy changed, or whether the government's position became weaker across case after case. The deeper question is whether anyone inside the system saw the pattern while it was happening. And according to the order, they did. Not once, not quietly, not in some vague hallway concern that never made it into writing. 5 formal warnings moved through official channels while the disputed decisions were still unfolding across the federal docket. The first warning arrived on October 12, 2025. It flagged what the memo called a substantial conflict exposure tied to ongoing financial relationships inside the litigation team. At that moment, the pharmaceutical pricing case was already beginning to shift. Discovery was being narrowed. Document categories were disappearing from reach. The government's strongest evidence path was getting thinner. The second warning came on November 21, 2025. This one went further. It did not simply point to conflict risk. It identified early signs of strategic drift inconsistent with the government's documented case posture. That was not soft language. That was a career office saying the cases were no longer moving in the direction the records supported. Then came February 9, 2026. By then, the infrastructure fraud prosecution had already seen its settlement authority slashed by $47 million. 17 defendants had been pushed away from the central liability theory. Internal objections had started to surface, and still the senior response remained buried in silence. The fourth warning landed on March 18, 2026. By that point, the issue was no longer limited to one case or one decision. The warning described cumulative exposure across multiple active matters. In plain language, the problem was spreading. What began as a conflict concern had become a pattern, touching pharmaceutical pricing, infrastructure contracts, environmental enforcement, civil rights litigation, and at least 18 additional matters. Then, on April 11, 2026, the fifth warning reached the office. This was the final bell. By then, 26 transfers had moved through the connected network. More than $5.3 million had changed hands. Dozens of strategic decisions had shifted within short windows of those transfers. 9 disclosure forms had left out material relationship details. 4 career prosecutors had objected in writing. A key environmental witness had vanished from the witness list, with no explanation beyond 2 cold words in a database. And still, the record shows no complete documented response. That silence is what gives page 36 its force. Because warnings change everything. Without warnings, officials can argue they did not see the pattern clearly. With warnings, the question becomes much harder. Who received them? Who read them? Who decided not to act? And why did the same strategic movement continue after each warning arrived? That is why the judge's use of the word "throughout" matters so much. He was not looking at a pattern discovered only after the damage was done. He was looking at warnings issued while the damage was still being made. The institution was not blind. The record shows it was alerted repeatedly as the cases kept moving in the same direction. 1 warning can be missed, 2 can be delayed, 3 can be explained by bureaucracy. But 5 warnings across 7 months, each one sharper than the last, followed by the same silence and the same strategic drift, no longer look like administrative failure. They look like a system choosing not to stop what the record was already showing. Now, to be fair, the administration's defenders do have an argument, and it is not a weak one on the surface. They will say complex federal litigation never moves for one reason alone. A case can shift because witnesses become unreliable, evidence can weaken, judges can signal concern, agencies can change priorities, resources can tighten. Settlement value can move when the risk of trial changes. No serious lawyer would pretend that every strategic decision in a federal prosecution has one single cause. That is the argument they are preparing to make. They will say the transfer timeline looks dramatic, but timing alone is not causation. They will say a payment appearing near a litigation decision does not prove the payment caused the decision. They will say the judge connected dots that should have remained separate. And they will almost certainly argue that the word "throughout" stretches the record further than an appeals court should allow. That is the cleanest version of their defense. But the problem is that this record is not built on timing alone. If it were only 26 transfers and 26 decisions, the administration would have room to fight. They could call it coincidence. They could call it ordinary litigation movement. They could bury it under technical language and ask the appeals court to narrow the finding. But that is not all the judge had. The record had missing disclosures. It had internal warnings. It had case logs edited after disputed decisions. It had review memos with labels but no real explanations. It had a key witness removed with no meeting, no credibility issue, and no evidentiary breakdown. And most damaging of all, it had career prosecutors objecting in writing while the strategy was changing. That is where the defense argument starts to crack. Because when outsiders complain, the government can say politics. When defendants complain, the government can say self-interest. When commentators complain, the government can say speculation. But when the attorneys inside the prosecution write that the new strategy does not match the evidence, that is different. In the infrastructure fraud case, 4 written objections were filed by career prosecutors who were closest to the record. They were not guessing from the outside. They were working the evidence, preparing the witnesses, reviewing the billing trail, and watching the case get pulled away from the strongest theory. Those objections did not say, "We prefer a different strategy." They said the direction being taken was inconsistent with the evidence and inconsistent with the prosecution's best interests. Then came the silence. No full response. No documented legal justification. No detailed explanation showing why those prosecutors were wrong. Just the same pattern continuing across other matters. That silence matters, because if independent case-based reasons existed, the record should have been full of them. In federal litigation, major strategy changes leave footprints. Witness problems leave memos. Discovery changes leave analysis. Settlement reductions leave risk assessments. Expert removals leave written evaluations. But here, in the places where explanations should have been strongest, the record became thin. And that is why the counterargument cannot carry the whole weight. The administration can challenge the judge's language. It can attack the scope. It can argue that material influence is too broad and throughout is too aggressive. But it still has to explain why the same kind of decision kept appearing after the same kind of transfer, across the same connected network, while the same warnings were being ignored. That is not one coincidence. That is a pattern with witnesses, a pattern with documents, a pattern with internal objections written before the public ever knew there was a scandal. And once that kind of pattern enters the court record, it does not disappear because someone calls the remedy excessive. Now here is the part that makes page 36 far more dangerous than a disciplinary order. If this were only about attorney conduct, the remedy would be painful but limited. Remove the lawyers, replace the litigation team. Refer the matter for internal discipline. Tighten the conflict rules. Issue a statement. Move on. That is the version the administration would prefer the public to believe. But that is not what page 36 does. Page 36 does not simply say the lawyers had a conflict. It says the strategic direction of active federal cases was materially influenced by financial considerations working against the government's own position. That is a different category of damage. That does not stop at the courtroom table. That reaches backward into every decision those lawyers made while they were managing the cases. Think about what that means. For 21 months, evidence decisions may have been shaped inside that environment. Witness lists may have been altered inside that environment. Settlement numbers may have been lowered inside that environment. Discovery demands may have been narrowed inside that environment. Expert testimony may have been abandoned before it ever reached a jury. That is why the replacement of the legal team does not solve the problem. A new lawyer can stand up tomorrow and tell the court the government is ready to proceed. But that new lawyer cannot instantly recover a witness who was removed months earlier. He cannot rebuild a discovery record that was deliberately narrowed. He cannot undo a settlement framework that changed leverage. He cannot restore pressure that disappeared before trial strategy was ever finalized. The damage, if the finding holds, is already inside the cases. And that is where the next legal battle begins. Defendants in those 24 federal matters now have a reason to challenge what happened during the disputed period. They can ask whether the government acted in good faith. They can demand hearings. They can seek production of internal records. They can question why certain witnesses vanished, why certain motions were withdrawn, why certain theories were softened, and why certain settlement positions suddenly became more favorable to the other side. One filing becomes 10. 10 become 30. 30 become an avalanche. The pharmaceutical pricing defendants will point to the narrowed discovery and the lowered damages theory. The infrastructure contractors will point to the $47 million reduction and the 17 defendants pushed out of the main liability structure. The environmental targets will point to the missing witness and the two-word database entry that tried to explain it away. And the other matters will follow. Civil rights cases, financial misconduct cases, public contracting disputes. Enforcement actions that were supposed to carry the weight of the federal government may now be dragged back into court under one question. Was the case managed for justice, or was it managed around money? That is why the language near the end of the order matters. The judge did not close the door on consequences. He reserved the unresolved determinations. In plain English, he left the hardest part for what comes next. Because disqualification fixes the future, it does not cleanse the past. And the past is exactly where this record points. 24 cases, 21 months, 26 transfers. More than $5.3 million moving through a connected network. 5 warnings, 4 written objections, 9 incomplete disclosures, 1 removed witness, and 1 sentence on page 36 tying the whole structure together. That sentence does not end careers only. It puts every affected prosecution under a shadow. The court can replace the lawyers. The department can issue statements. The appellate panel can narrow language, pause deadlines, or argue over procedure. But none of that erases the central question now sitting in the federal record. What happens to the cases that were already changed before anyone stepped in? Strip away the legal terminology for a moment. Strip away the conflict rules, the disclosure forms, the transfer charts, the emergency filings, the appellate questions, and the procedural language that makes a scandal like this feel distant from ordinary people. What remains is one simple question. For 21 months, were federal cases being managed in the name of the public interest, or were they being quietly shaped by financial interests the public was never supposed to see? That is what page 36 leaves behind. Not a rumor, not a campaign talking point, not a cable news argument that disappears after the next headline cycle. A sentence in a federal court record, supported by months of documentation, pointing to 24 active cases, 26 transfers, more than $5. 3 million moving through a connected network, 5 ignored warnings, 4 written objections, 9 incomplete disclosures, and a witness removed with nothing more than 2 words in a database. Strategic reassessment. Those 2 words may become one of the most important phrases in this entire record, because if the finding holds, the damage does not end with the lawyers who were removed. It reaches into every decision made during that period, every narrowed discovery request, every abandoned witness, every reduced settlement position, every theory that was softened before it reached trial. In my view, the most disturbing part of this story is not only the money, it is the silence. Silence after warnings, silence after objections, silence after the record started showing the same pattern again and again. But that is just my view. What do you think? Is page 36 proof of a deeper institutional failure? Or do you believe the appeals court will narrow the finding and treat this as a legal overreach? Which part matters most to you? The transfers, the ignored warnings, the missing witness, or the prosecutors who objected from inside the case? Leave your thoughts below, because this story is not finished. It is only entering the next docket.